Good afternoon and welcome to the Court of Appeals. We have two cases on our 1:30 docket and one case on our 2:30 docket. I see counsel in our first case, Estate of King, are set up and ready to proceed. Does either of you have any questions? For purposes of our spectators, if anyone has a cell phone or similar device, would you please turn it off so that the lawyers are not interrupted? Otherwise, we're ready for argument in Estate of King. And I say there are multiple lawyers. If any of you is going to split your argument with co-counsel, it's up to you to keep track of the time.
May it please the court, I am Steve Long. I'm appearing with my partner, Kevin Brown, and my registration number is 17252. I'm here representing the appellant, Mrs. Julie King, the spouse at the time that the decedent passed. There are just really a limited number of facts that I think are material, and I believe those facts are undisputed. I don't really think this is about a dispute over facts. I think it's more a question of the application of the omitted spouse statute to the facts which are undisputed. The essential facts, though, are that Mark King, the decedent, had a will which he created in year 2000. It provided for his estate essentially to go to his wife at that time, Brenda King, and his two children. He changed that will twice, in 2003 with a codicil and in 2006. That was the last time that Mark King acted in any manner related to his will and the trusts therein. He was divorced from Brenda King in May of 2015. In July of 2015, he provided a beneficiary designation in a life insurance plan which provided for $10 million to his former wife, who at the time was no longer married to him, $10 million to his children, and $5 million split between two essentially girlfriends. $1 million to a woman named Jana Olson, and $4 million to a woman named Julie Pelletier, who later married and became Julie King, my client. He was not married at the time that designation was established, nor was he engaged. He married Julie King then, thereafter, in September of 2015, and never amended or modified in any way or expressed any intent one way or the other regarding his will. Indeed, the last change that he made to his will and estate plan, as I said, was in 2006. Subsequent to that, material things had occurred. The estate laws changed. His estate increased in size significantly. He was divorced, and he remarried, but despite that, took no action. On July 13th of 2016, the year after, he died, and his death was unexpected, undisputed, a heart attack while on a vacation trip with his kids. And the question then, based on those undisputed facts before the court, is essentially whether Mark King intended the $4 million in life insurance, which he arranged when Julie King was his girlfriend, to be in lieu of a testamentary provision. If it was his intent to do that, then the omitted spouse statute, which would otherwise apply, would not benefit the Julie King. In other words, it is an exception to that statute.
Wasn't there another undisputed fact, kind of an intervening event in between there, where once they were married, that he went out of his way to make clear that he was changing the designation from his friend Julie to his spouse Julie? And what significance would that have?
Yes, Your Honor. I think Your Honor is correct. I don't know that he went out of his way, but he did modify that. And the only evidence on that is what, in the record, is what he said at the time, which was, I see that it's not clear that this would go to Julie King, who is now my wife, but I do want that to occur. So the relevance of that is he changed the name to make sure that gift, if you will, that provision of life insurance that he made when she was a girlfriend would actually get to her and not otherwise. It was essentially a reaffirmation of his life insurance plan. Now, it is clear in this record that Mr. King provided life insurance to people who were in his will, his former wife and his children, and to Jana Olson, who was not in his will, to suggest that the provision of life insurance was for the purpose of providing for someone instead of, in lieu of, a testamentary trust, I think is not supported by the facts. The facts, undisputed, are that he supplemented testamentary provisions to family members, not that he did it in lieu of. And so we suggest his change of the name of beneficiary did nothing to change what he had done before the marriage. The real important fact is what did he do with regard to his will and trust? And this is where there is absolutely no evidence. The trial court, the magistrate even said, I have no evidence of what he intended. But despite that, the trial court found that he intended, he had the specific intent to omit his spouse, which is necessary under Colorado law, the omitted spouse statute, because otherwise the law protects the spouse. That's omitted spouse statute, is to protect what I would submit to the court is the very thing that happened here, which is that he did nothing.
Is, where there's no direct evidence of his intent, isn't that going to be a matter of inference?
I would completely agree, Your Honor,
All right.
and I think that's the important question for the court is what the lower court, and if I interrupted, Your Honor,
No,
I
go ahead.
apologize. I was going to say, and what the lower court did is it basically, he relied on, I think this is a fair reading of his order. I've been over it many times. I know you'll go over it only probably once or twice and understand it completely, but the reality is really all he relied on to infer this clear intent, absent any direct evidence, is the life insurance size and the shortness of the marriage.
And arguably, Mr. King's overall sophistication, business acumen.
He referenced that, but I could not see a way that was tied to an estate plan, which I would suggest the record is much to the contrary. He did nothing since 2006.
Well, I mean, I guess my concern is, regardless of how we would weigh the facts, were we sitting as the trial court, it seems to me that you're making an argument based on the evidence that the magistrate judge did not accept. And I'm not sure it's up to us to revisit or reweigh evidence, except in the most compelling of cases.
I understand, Your Honor, and Your Honor suggests, what is our standard of review, and do we need to defer to the finding of the trial court?
Well,
And
don't we always defer to factual decisions of the lower court?
And our position is yes, what Your Honor just said, the answer is yes, but here, what we have is a situation in which those facts, every time we talk about actual facts and evidence, there's not a dispute about them. The only thing that was disputed.
Well, my question was poorly framed. Let me try better. Isn't the magistrate's finding, inferring an intent, itself a factual finding to which we must defer?
I do not believe so, Your Honor, because I think the finding was based on an application of law, the statute, the omitted spouse statute. We took a set of undisputed facts and we applied the law, the omitted spouse statute, which in our view requires not only its literal words, but its purpose. Its purpose is clear, to make sure that when there is no action, that we do not take from that an intent to omit. We must find a clear intent that, in this case, a life insurance designation before marriage was intended to be in lieu of a testamentary trust. Now, there's no evidence, I would submit, Your Honor, there's no fact evidence. The determination was based on an application of the legal principles of the statute. This is why we maintain that the standard of review is de novo. Mixed questions of fact and law. It is true, the facts, the question of, things like, did he provide life insurance? When did he provide the life insurance? What was if he said something surrounding that event? I think those things are typical fact decisions that should be afforded deference and subject to an abuse of discretion standard. But here, Your Honor, all we believe the magistrate did is took the legal principles and purpose of the omitted spouse statute and applied it to the undisputed fact. So I would say it was misapplied. It just
Well, but I apologize.
No, please go ahead.
But his intent isn't undisputed. His intent is the heart and soul of the case.
Well,
So
there's
why
n-
isn't that also essentially a factual determination? And why isn't that a factual inference that the magistrate draws from other undisputed evidence? And, maybe it tried it to a different judge?
Well,
A different judge would draw a different inference.
I'm not, Your Honor, I'm not conceding that abuse of discretion standard is necessary for the reasons I've said. But I would say, Your Honor, I believe there has been an abuse in the sense that there's absolutely nothing in this record other than his inaction, which really gives rise to an expression that there was an omission. And that's what the statute is trying to say, no, that's not the law of this state. It's simply not the law. So I see that I have 3 minutes remaining, and if you had a question, Your Honor, I'll stay. Otherwise, I would like to reserve.
No, I want you to reserve your time.
Is that okay?
Yeah.
Thank you, Your Honor.
Your Honors, my name is Craig Pankratz. My registration number is 52953, I am the attorney representing the personal representative in this case, Carolyn Bell. She is present at council table. Also present at council table is Ms. Carrie Johnson. She is the attorney for the decedent's children. We intend to split our time today. I'll be taking 10 minutes and Ms. Johnson will be taking 5. And Your Honors, may it please the court. As Your Honor, Judge Webb said, this is actually, the heart and soul of this case is the intent of Mr. King. And intent is a pure question of fact. He either had the intent or he didn't. It doesn't matter whether or not the law says A, B, or C. He either intended the transfer to be in lieu of a testamentary provision or he didn't. So
Is that your burden, to prove his intent?
it was below. Here on appeal,
Well,
it's
no,
not.
I meant below.
Yes, below it was definitely our burden to prove intent because I think as correctly stated in the appellant's brief, the initial burden belonged to Ms. King to show that she was admitted, and then the burden then shifted to Ms. Bell to show that one of the exceptions applies. However, because the trial court found that Mr. King did in fact have that intent, the standard of review is very deferential to this finding of fact,
Let me
as Your Honor
push
said.
behind a little bit this question of his intent.
Yes.
Is it also necessary for there to have been a finding that he actually considered his estate plan?
I don't think it's a necessary consideration that he had to have had.
Well, how could he intend to provide outside of his will unless he consciously considered his will?
Right, and I think that goes to these factors that we have been asked to discuss as we came today. As I think about it, yes, I think that's ultimately the heart and soul of what that question is did he ultimately consider, how am I going to provide for her? Did he consider, well, am I going to do it in life insurance? Am I going to do it to the will? So I think essentially, yes, I think you're right. He ultimately would have had to consider his estate plan in general.
Is there any finding that he did?
No, there's not. However, ultimately, well, there's no express finding. The finding is that he intended that transfer of life insurance to be in lieu of a testamentary provision. Ultimately, there's an implicit finding there that he did consider his estate plan and nevertheless continue to move forward with life insurance. In light of this court's recent order, I have prepared some factors to consider, whether they're mandatory or permissive, I'm not sure, but the omitted spouse statute itself identifies two specific factors. The first factor itself is the statements of the testator. As we all know, when it comes to someone's intent, the only direct evidence of that person's intent would be what he or she has said. We don't have that in this case. We don't have any statements regarding his intent, regarding his estate plan, life insurance, what he intended to do with Ms. King. So really that factor's off the table. The next factor that is discussed in the statute is the amount of the transfer itself. I think it's telling that these two factors are identified in the statute because it implies the weight that can be given to these two categories of evidence. Obviously, the statements themselves, in general, are going to control, if there are any. The amount of the transfer is also strong circumstantial evidence of the intent. In fact, 2 jurisdictions have actually found that a large transfer in and of itself is sufficient to support a finding that the testator intended a transfer to be in lieu of a testamentary provision.
Do you have to know what the total value of the estate was in order to reach that conclusion?
I don't think it's necessary, but it certainly can be considered. And that comes into the third, I guess it's a factor, but it's not really a factor in the statute, and that talks about other evidence. And I think the use of the term other evidence opens up a wide variety of factors that can be considered when determining whether or not someone intended a transfer to be in lieu of a testamentary provision.
Counsel, what about the timing of the life insurance policy here? Because clearly they weren't married when Mr. King provided for his girlfriend at the time. How does that, I mean, when you're looking at the amount of the transfer, it was an amount that was actually provided before they were married.
And I think we need to look at this evidence practically. Is it something that can be considered? Absolutely. I think we need to look at this with any other intent finding, and that is by the totality of circumstances. And yes, initially they were not married, and that is certainly something that can be considered. But I think we can't view that in isolation. What we need to do is, again, look at all of the circumstances surrounding that transfer itself. He designated her as a beneficiary. I think it's notable that he listed her as a partner, which signifies something more than just a girlfriend. In fact, her address was his address on that form. They'd moved in together. They were essentially married even though they hadn't gone through that formality yet. But then we need to continue on, just as Your Honor pointed out, of what happened after the marriage. After the marriage, he made sure that she was specifically designated as his wife, and on top of that, made sure that that $4 million was going to her, that it was very clear that that's what she would receive. So considering that ratification itself, in light of, yes, the prior designation, that's strong circumstantial evidence of what his intent was as far as taking care of her.
What about the fact that, as was pointed out by the magistrate, and I think you in your brief, that he's a sophisticated businessman, and yet he didn't make mention of the fact that his change in his life insurance policy was intended to be in lieu of his will?
Yes, he was a sophisticated businessman. I think we also look at the other evidence there that talked about how careful he was about his finances, how careful he was. Well, I don't think that careful is the right word. I think the person who testified said that he is someone who would have been aware of his estate plan, and had he wanted to change it, he would have. That gives rise to an inference that the fact that he didn't change it was intentional. Again, we have to look at all of these facts in a totality rather than as specific isolated circumstances. I think the fact that he was sophisticated, in addition to the fact that he didn't just sit and do nothing once he started a relationship with Ms. King. He took steps to provide for her. He took action to provide for her. Now, he did not amend his will, but we know he knew how to amend his will. He'd done it before. We know that he knew how to amend the trust. He'd done it before. So as we're looking at this totality of circumstances, had he wanted to amend the will to provide for Ms. King, he certainly could have. And then we look at the fact that he took action to provide for her after their marriage through life insurance. Those coupled together indicate that his intent was not to amend the will. His intent was instead to provide for her through life insurance. Indeed, there are multiple factors that I was able to identify in case law from other jurisdictions, also some factors that are inferred from the trial court's order itself. And frankly, there's about 17 that I could pull out, and I'll just give a few examples. There's 8 in Alabama. Those include things like the ratio between the transfer and the value of the estate. Some get a little more specific and say, well, the ratio between the transfer itself and what she would have received as an intestate share. We look at other gifts that were received in Alabama, duration of the marriage, the separate estate of the surviving spouse, the factor that, Your Honor, Judge Webb, the consideration between the marriage, the admitted spouse, and the will. Let's see. Other jurisdictions include, in New Mexico, looking at what the intent was at the time of the transfer itself. The trial court thought of things such as the financial ability and practices as we've discussed, looked at the former marriage with Brenda, looked at children from a prior relationship, looked at the extent and complexity of the testator's estate plan, the testator's understanding of the estate plan. So, I mean, there's so many things that we could consider that I think that other evidence prong really is an encouragement to look at everything. Now, it's our position that the size of the transfer itself is sufficient in and of itself to support the trial court's finding. But again,
As you read these factors, how does the duration of the marriage, which I assume means the date of the marriage to the date of death, cut? I mean, if it's a short period of time, does that, undercut the inference you're arguing for? And if it was a very long period of time, it would support the inference?
I think the longer the marriage, I think we could even look at the duration of the romantic relationship if we wanted to. I think the longer the relationship, the more likely it is that there's an intent to provide additional support. Unfortunately, the way relationships tend to go is many can be short, but as the relationships stand the test of time, there's more of it, and as the relationship develops, have children, etc., there's going to be a reasonable inference that's inferred there that the testator wants to do more to take care of that spouse than, say, a spouse of a short duration. Again, I'd like to reserve the remainder of the time for Ms. Johnson, but based on these things, we're asking you to affirm the trial court's orders. Thank you.
Good afternoon, and may it please the court. My name is Carrie Johnson, and as Mr. Pankratz indicated, I'm the attorney for the decedent's children, Michael and Colton King. Michael and Colton agree with and endorse the personal representative's arguments. And I take a few minutes of the court's time today during this argument solely because fundamentally it is Colton and Michael who appellant seeks to disinherit. And it is Colton and Michael who have suffered the most from both their father's death and from enduring these proceedings over the past couple of years. So while Michael and Colton certainly endorse the arguments set forth by the personal representative and certainly agree that the trial court's findings with respect to the size of the transfer and the intent of the decedent should not be disturbed, we also want to emphasize that even if for any reason the court determines that none of the exceptions to the omitted spouse statute apply, 85% of the estate is inaccessible to Mrs. King. That's because it is the amount placed in trust for the benefit of Colton and Michael as Mr. King, the decedent's children. There are two trusts that are at issue in this case. There's the family trust and the marital trust. Under both, the children are the beneficiaries. The estate was set up such that essentially all of Mr. King's assets that were in the estate were placed in trust. 85% of which were for the benefit of the children. These issues have not been specifically discussed, but of course the omitted spouse statute itself, in addition to these three exceptions that can take an omitted spouse out of any sort of entitlement to a share of the estate, the initial component of that statute states that the omitted spouse is only entitled to receive the portion of the estate which is not devised outright nor in trust for the benefit of a child of the testator who was born before the testator married the surviving spouse, which of course is exactly what happened here. Appellant argues that the purpose of the omitted spouse statute is to protect the omitted spouse. We would posit that actually that's the secondary purpose. The primary purpose is really to protect the children of the decedent who is not also the children of the omitted spouse. And that is set forth right just in the language of the statute itself because it supplies as its the only beneficiaries who are listed beyond the omitted spouse are the children themselves. Appellant also argues within her briefing that trusts that are not considered devises under Colorado law and therefore should somehow be accepted from the exclusion for purposes of the statute. That simply isn't true, and the cases that are relied upon by the appellant for this proposition do not even speak to trusts as devises, whereas here the omitted spouse statute specifically includes trusts as being included within the definition of devises that are excluded from accessibility by an omitted spouse.
So if we were to accept your interpretation and were to rule for Mrs. King, it would have no effect on the children?
Absolutely. If you accept our interpretation, it would have zero effect on the children because 85% of the estate would remain in trust for the children and would be inaccessible to Mrs. King. Her omitted spouse share would have to come out of effectively the charitable gifts and gifts to other family members who are not protected by the plain language of the omitted spouse statute as the children are. Now, the appellant argues that the divorce statute, or that the fact that the trusts themselves actually list Brenda King, Mr. King's ex-wife, as one of the beneficiaries or the primary beneficiary, removes the trust as actually being for the benefit of the children. But as our briefs explain, and we're already quickly running out of time, the divorce statute, which must be read in harmony with the omitted spouse statute, actually says that in the event of a divorce, then the ex-spouse is considered to have predeceased the decedent for purposes of operation of the statute. In our view, those statutes should be read together in harmony, and that enables the determination that the children are in fact recipients of, or beneficiaries of the trust, rather. And with that, because the time is up, I will just say we will rest on our brief and ask that the court uphold the trial court's findings. Thank you.
I thought I had 306, but I have 258. So, disinherit. I'm not sure the materiality, but the facts are that the children have received $10 million in life insurance, and even if we were to prevail, we'll get 50% of the estate. So I don't think that there's any effort here to disinherit anyone. It's an effort to provide for the legal provisions that are in the law. Second, the duration of the marriage. This marriage ended randomly, unexpectedly. It would be different if we're talking about a young person marrying an old person near death, or it would be different if the person was sick or infirm and expected to die. This marriage should have gone on and gone on and gone on. It was interrupted by an unexpected death. It is of, in our view, no materiality as a result, though it can be considered. But I think because it was unexpected, it is not significant. Finally, the evidence that, Your Honor, Judge, you ask about, does there need to be any evidence that he considered the will at all after the marriage to Julie King? And we would submit to the court that absolutely that's necessary, because otherwise you have pure inaction with nothing. And in fact, though it's New Mexico, not Colorado, that's the Supreme Court in New Mexico in the Taggart case, that case turned on a very important point, which was at the time of the transfer there, which was after the marriage, but most importantly, the decedent said, I did this so that you can get your money and not have to wait for the probate. Now see, I think that that is the kind of evidence that would be necessary when you have absolutely no action and the transfer actually occurred before the marriage
But let me
to
ask you
change
this.
that.
I'm sorry, but let me ask you this, counsel. Certainly, the testator's statements are the strongest possible evidence we could get, and there's no dispute. We don't have that here. But statute goes on to talk about, or is reasonably inferred from the amount of the transfer or other evidence. So it looks beyond just statements of the testator here in
Well,
Colorado.
yes, Your Honor, I accept that and I understand that. The reality is the burden is there. There was no evidence that his life insurance gift when they were girlfriend and boyfriend was intended to replace a testamentary will, because there's no evidence he considered the will. And finally, just on the marital trust, the 85% that was just mentioned, this is a pretty detailed area, but just the most important aspect of this, that 85% we're talking about, if we are an omitted spouse, there's two trusts, a family trust, which was for the wife, Brenda King, and the children, but primarily for the wife. The second is a marital trust, all for the wife. She did not predecease him. There's a big difference in the divorce statutes between predeceasing and disclaiming your interest, which is what the divorce statute said the legal effect of divorce is. And that is section 50, or Colorado statute 1511-804.
So she's not treated as if she were predeceased, as if she predeceased him?
No, Your Honor, that is not the way the statute works. The statute basically says the treatment that a divorced spouse receives is that is legally as if she disclaimed her interest. That's expressly stated in the statute I just cited, B, section B. What is missing here is the fact that overriding all of this is on the omitted spouse statute, you must make a devise to the children. For a spouse, former spouse, to have disclaimed her interest is not the same as a devise for the benefit of the children. And that's the reason that we believe if we are an omitted spouse, that we're entitled to our intestate share of that portion, which is limited to 50%. Thank you.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. When the tables are cleared, counsel in our next case, Kirchhoff, may set up. Well, gentlemen, I see we have experienced counsel. Does either of you have any questions concerning our procedures?
No, Your Honor.
In that case, we are ready for argument in David and Sharon Kirchhoff versus Multicam Group.
May it please the court, my name is Ben Mead, counsel for David and Sharon Kirchhoff. My attorney registration number is 40375. We are asking this court to reverse the district court's grant of summary judgment, and I plan to begin by answering the question that this court submitted to the parties before oral argument. With any remaining time, I plan to address the lockout tagout issue and any other issues. Now, this court's question is, quote, does the reference in the Roque affidavit to unnamed Multicam employees satisfy the scope of the agency or employment requirement of CRE 801 D2D, and what authority supports your position? And of course, that evidentiary cite is for admissions of a party opponent. Now, two preliminary matters before addressing the core of this question. First, it's our position this court shouldn't reach the hearsay objection on the merits because defendant failed to get a ruling on that objection and therefore waive the objection. And second, this question assumes that the Multicam employees are unnamed, but names are provided in Mr. Roque's affidavit as well as on the sign-in sheets. It may be more accurate to say it's unspecified who of these named employees made the statements. But in any event, the core of this question is really what authority, that is, what legal authority supports our position. Now, in our reply brief, we collect cases from 3 federal circuits. Those are all the federal circuits that I found addressing the issue, and cited a case from the Colorado Court of Appeals and the Colorado Supreme Court. All of these cases support the proposition that you do not have to name the declarant in order to fit within this hearsay exclusion. But I want to focus really on the Pappas case from the Second Circuit, because that case really analyzes this particular issue in depth. And
let me try to add a layer to the court's questions, and you may want to fold this into your argument or address it separately. It seems to me that the heart of Mr. Roque's affidavit is not a statement of fact, it's an expression of opinion. Quote, "This was human error," close quote. Now, and that seems to me to be ambiguous in a couple of ways. First, it's not entirely clear who said that, whether this was one of the unnamed or ambiguously named Multicam employees, or whether that is Mr. Roque's opinion himself. And a corollary of that question would be, doesn't the affidavit have to say something about the credentials or background or experience or education of the person offering such an opinion, which essentially is an expert opinion here, before it can be given any evidentiary significance?
there's a lot to unpack there.
And take it as however you wish.
And let me unpack all of it. So to begin with, our case, the Roque affidavit doesn't rise and fall solely on the statement, "This was human error." Under this narrative of the events that he relays, in which Multicam pumps this dangerous biocide into tanks that are still under construction and therefore can't contain it, that alone is enough. We don't need to demonstrate that Multicam owed a duty.
Well, the leakage didn't occur because the tanks couldn't contain it. It occurred because somebody opened the valve.
There are two narratives of the event. There's Mr. Roque's narrative of the event in his sworn affidavit, and then there's the narrative from Mr. Peprocki and other evidence. So looking solely at Mr. Roque's narrative of the event, under that narrative, the biocide leaked because the separator was still under construction. It was incomplete and it couldn't contain it.
Well, where does it say that? I mean, we're talking about 3 pages. I don't see a statement in here that the leakage occurred because the separator couldn't contain it.
What it says is, I went to one of the unfinished separators. It was not yet completely built nor was operational. So he speaks to his witnessing the separator being incomplete. He also says that because the separator had never been used, the separator did not need to be treated, and because the separator was not operational, there was a biocide spray.
Well, I mean, conceptually, I understand what you're trying to say, that if it's incomplete, maybe it leaks, maybe it hasn't been pressure tested, all kinds of things. I just don't see that in the affidavit.
The affidavit says that the separator was unfinished, says that the separator was not completely built. And it says that because it was, and that's the first paragraph on the second page of the affidavit. He also says that he was told that the separator was still being constructed. So that further suggests it's an incomplete separator. The incomplete separator he's referencing in the paragraph previous. However, because the separator had never been used, the separator did not need to be treated, and because it was not yet operational, there was a biocide spray. So there's no discussion of a leak even, there's no discussion of anybody opening the separator. That's an entirely separate narrative. So, but I want to return to your point, because you opened by asking, so I do think that this is a different narrative from the narrative we get from other people.
Well, you know,
And I know,
what about this was human error? Is that his opinion, or is he quoting somebody else's, or don't we know?
I would say that this second paragraph is all what he has heard from other people. But even, you know, because he says, I was told, and then gives a narrative of how the spill occurred. And he says earlier in the affidavit that he wasn't on site. And then in the following paragraph, he says, my
Okay,
coworkers
well,
told me.
So for purposes of this case, your position is this was human error, is a party admission by some other multi-chem employee, not Mr. Roke's personal opinion, correct? I mean, it has to
Yes.
be one or the other.
Yes.
Okay. What do we know about the other employees who may have made this statement that would qualify them to express an opinion?
For omissions of a party opponent, there is no personal knowledge requirement.
No, that's not personal knowledge. That's a basis in training or experience to express an opinion.
Let me also go back. I don't know that it has to be one or the other. I think it's you said it's either going to be one or the other. He says earlier that he himself witnessed the separators and saw that they were under construction. So he saw that the separators were incomplete. Then he goes through a narrative of, here's what I was told about how the spill had occurred. And I think it's natural that what he's stating can be a conclusion that they generally reach together. And I want to go to your question having to do with credentials, because Mr. Roque provides his credentials in his sworn affidavit.
But that's irrelevant if he's repeating something, he's just repeating something somebody else said, which is why I asked you to take a position on what he's doing.
What I'll also say is that any evidentiary objection having to do with, oh, this is expert testimony, none of that was raised below. So we'd be now addressing that for the first time on appeal. And I don't think that we can say as a matter of law, or rather, it's not even that we can't say it as a matter of law, it's procedurally improper to be addressing that issue now. The district court would have to make that determination. You'd have to have a 702 objection raised. And besides which, I think we are getting far afield from how this is presented in the briefs. Really, the core of the issue is a hearsay objection that the defendants raised when it comes to the Roque affidavit. But I do want to answer any other questions about the Roque affidavit before turning to the lockout tagout issue. And I do
So the plaintiff's theory is that there was a chemical spill, and the spill occurred the moment that a multi-chem poured the chemical into the unfinished separator.
there's two alternative theories of liability.
Yeah, I'm asking what the plaintiffs.
But under either theory, our position is that we win. There's the Peprocki's narrative, where the biocide is pumped into separators that are incomplete, therefore the biocide sprays out. And there's the testimony of Mr. Peprocki, also a multi-chem employee, which is that multi-chem failed to stay on site and make sure the tanks were locked. And because they were not locked, somebody came in the night and opened them up. They're two different narratives.
Counsel, the record, Mr. Uris's deposition indicates that there were problems with Phase 1 of bringing these vessels online. And that Phase 2, which is pre-treating these vessels with the biocide to deal with the water problem that was in everything, that was the purpose of this. Is there anything in the record to show that Multichem was told that this procedure was a result of problems with Phase 1?
I'm afraid I can't answer that question.
Okay.
Is there something specific? that
No,
you're
I
driving
just wondered, because it seems that Mr. Roque says in his affidavit, putting biocide in an unfinished separator isn't necessary. You don't need to pre-treat it because it's not operational. But we have in the record Mr. Urias's testimony that, yes, in fact, they did need to pre-treat it. So that's an issue of fact. What I was trying to get at is whether Multichem knew this. Would Multichem have any way of knowing this, or any way of knowing that they shouldn't be doing what they had been hired to do?
Under Mr. Roke's version of the events, because there's two separate narratives. Under Mr. Roke's version of the events, the tanks, the separators, you can see that they're incomplete because he testifies to having seen that they were incomplete. So that would suggest you're not supposed to pump the biocide into an incomplete separator.
So they have a duty, even if they're told by Noble, they have a duty not to pour it in there.
Yes, and we get into that issue in depth in our briefs. The fact that Noble owes a duty doesn't mean that Multichem does not. You can't contract around your duties and everything else. So even if they heard such thing from Noble, that wouldn't obviate their duty. And I do want to touch on, again, there's two separate narratives of the events. Mr. Roke's narrative, Mr. Paprocki's narrative. Under Paprocki's narrative, Multichem pumps the biocide into these tanks. But Multichem's own employees testify that these tanks should be locked. They should be locked and tagged. But Multichem leaves before the lockout tagout is conducted. And under those circumstances, Multichem did owe a duty because it was engaged in a very risky activity. It was foreseeable that some unknowing worker would open the tanks. And in fact, that is what happened. And it would be very little burden placed on Multichem under those circumstances. And if there's any questions about any of this, I'm happy to entertain them. If not, I would reserve the remainder of my time.
May it please the court, Alan Epstein on behalf of Multichem Group. My registration number is 10473. I will start off addressing the question directed to counsel by the court, and then backtrack if I can. The question the court asked the parties to consider is whether the reference in the Roque affidavit to unnamed Multichem employees satisfies the scope of agency or employment requirement of Rule 801D2D. It is Multichem's position that it does not. 801D2D characterizes as an admission by a party opponent a statement by the party's agent or servant concerning a matter within the scope of the agency or employment made during the existence of the relationship. The cases that Multichem relied on in its answer brief all hold to the contrary of what plaintiff's counsel is advancing, that under these types of circumstances, such statements do not qualify, as the Pennsylvania Federal District Court reasoned in Rabati v. Great Wolf Lodge, a case cited in Multichem's answer brief. Such statements do not qualify under Rule of Evidence 801D2 because the identity of the individual is not known, and it is not possible to determine that the statement was made by an employee within the scope of his or her employment. Other such cases cited in Multicam's answer brief are Harris v. Toys R Us and Tomanovich v. City of Indianapolis.
Counsel, how do you square that with the Stevens by and through Stevens case from Colorado, which dealt with the scope of employment and the identity of the declarant in that case was not known? And a division of our court said you could infer that this was a statement made by a Humana nurse based on the practice that was regularly followed. Because that's a Colorado case. To me, that's more persuasive than a Pennsylvania case or some other federal case.
Well, I would argue that in Stevens v. Humana, the statement at issue was held to be admissible under this rule because corroborating testimony by a transport team and a Humana nurse were sufficient to show that an agent of Humana made the statement. I think it's close, but it is distinguishable.
Is there anything in the record that shows that it could have come from someone other than the Multichem employees? I mean, if we look at Mr. Roke's affidavit, he's saying that Multichem employees said this, so who else could it be that's in the record that provided him with this information if it wasn't someone from Multichem?
I don't think you can tell, but you can't. But what you can tell which Multichem employee to whom he is referring. You also don't know, though, of those potential employees, what their jobs were, what they were qualified to say or do, what the scope of their agency of employment was. The Roke affidavit just says, I was told by somebody.
But do you agree or disagree with opposing counsel that you can identify who was there that day from the logs and from the depositions? I mean, don't we know who from Multichem was sent out there that day, except for maybe the person from North Dakota?
There are names provided in that list, but Mr. Roke doesn't identify who said what or what their jobs were.
Okay.
Let me ask a more fundamental question. The affidavit says, quote, "This was human error," close quote. How do we know from that whether the error was Nobles in asking that the biocide be pumped in, or was error of Multichem in following those orders?
You cannot. And in isolation, without any foundation behind who made that statement, or whether it's an opinion of another Multichem employee or Mr. Roke's opinion, there's no foundation given that any of these people had the qualifications to make such a statement. Just because these people drove the trucks to the site and dispersed biocide into the tanks doesn't mean they know anything about the science behind the tanks and whether you do or do not spray or put biocide into a tank when it is not completed. So I would say that confirms that that testimony should be inadmissible. You don't know whose opinion it is or what qualifications that person has to make such an opinion.
Where we're dealing with a party admission, is the qualifications of the speaker, I mean, not wholly apart from, scope of duty and so forth. I mean, is the qualification of the speaker to express the opinion part of an evidentiary foundation, or would it be up to, in this case, the defendant to say, well, that person may have said it, but they didn't know what they're talking about? In other words, on which side does the burden fall? I
think it's on the plaintiff's side to show that the plaintiff has the burden as the non-moving party after Multichem moved for summary judgment to establish that this was an opinion that is admissible as evidence. And why it's admissible as evidence is because the person rendering the opinion has the qualifications to render the opinion. And contrary to what counsel argued, Multichem did say, I think in both the motion for summary judgment and the reply brief, that Mr. Roke didn't have the qualifications to make this opinion. We may not have cited Rule 702, but we certainly said that. Counsel also argued that Multichem did not preserve this argument. Multichem's motion for summary judgment argued that the Roque anticipated that the Roque affidavit would be referenced and argued that it was inadmissible hearsay. In response to that, plaintiff raised Rule 801D2D. Our argument is in reply to that argument. It is still, we're still arguing it is inadmissible hearsay. So I don't think there's merit to the argument that this argument, our argument, wasn't raised. With respect to the lockout-tagout version of events, which assumes that what occurred didn't occur the way Mr. Roque described it, and instead it was the narrative in which Mr. Palumbo, who was a Noble employee, opened the valve and it spilled out later after Multichem had left the premises. Assuming that version of events, Multichem also did not owe a duty to do anything further after it left the facility. A Noble employee, Mr. Yeris, operated the valves on the vessel because third parties were not permitted to manipulate any of Noble's property. A Multichem employee told a Noble employee that the separator tank should be locked out and tagged out for as long as the biocide remained in the tanks. The tanks were Noble's property, not Multichem's. The duty to lock out and tag out was Noble's, not Multichem's. Multichem had no way of knowing that Noble would not do what it was supposed to do after Multichem left the premises. And the cases on which plaintiffs rely in attempting to impose a duty on Multichem to lock out or tag out the tank, Health One v. Rodriguez and Halliburton v. Public Service are distinguishable. In those cases, the defendants created dangerous conditions which imposed duties to ensure that the plaintiffs would not be injured after the conditions created were left unattended by the defendants. In this case, the dangerous conditions were created solely by Noble, assuming the Palumbo narrative. First, Noble did not lock out and tag out the tank. Then a Noble employee, Mr. Palumbo, violated protocol by opening a valve and releasing the biocide. Multichem's duty ended when it left the facility. Nor did Multichem owe a duty to report the spill to government authorities. Multichem was not a creating, exposing, or correcting employer for purposes of OSHA. Noble was. Therefore, Noble, not Multichem, owed any duty to report the spill. And plaintiffs suggest that Multichem owed a common law duty above and beyond any regulatory duty, but does not offer any authority to support that proposition.
Does Multichem have a duty when it arrives, taking the other narrative, and it sees that the separator is not finished, not complete, to take any action at this point to say we can't pour the biocide here because it's not finished, it's not complete?
I think that's Noble's duty. It's Noble asked Multichem to do that, and the only evidence that doing it is that was negligent is the statement in the Roque affidavit that this was human error, which again is a statement not based on the attestant's qualifications.
Is there any evidence in the record that the biocide leaked out because the vessel was not yet complete and pressure tested?
No. There isn't any independent evidence aside from the Roque affidavit, and the Roque affidavit just says it spilled when it was injected into the tank. This is what I was told. Okay. Backtracking, this case, plaintiffs brought claims against Multichem under the Premises Liability Act and common law negligence. And the Act provides the exclusive remedy against a landowner for injuries which occur as a result of conditions, activities, or circumstances on the landowner's property. So logically, that issue must be addressed and resolved before the common law negligence must be addressed. And under the reasoning of the courts in Collard v. Vista Paving and Jordan v. Panorama Orthopedics, under those decisions, Multichem was not a landowner. Yes, more than one party can be a landowner under the Act, but under these circumstances, Multichem was not. The title owner of the land on which the facility was situated was Wells Ranch. Noble was the owner of the facility and in control of it for all purposes and at all times. Multichem was an independent contractor whom Noble requested to deliver and inject the biocide into the tanks. Multichem injected the biocide into the tanks at Noble's direction and supervision, and Multichem's employee left the facility, and a Noble employee under the Palumbo version later released a valve on the vessel, causing the biocide to spill. So Multichem was not in possession of the facility. It does not come within the rubric of a landowner as that term has been interpreted by the Colorado appellate courts. Finally, plaintiff's negligent supervision claim fails because he did not identify what Multichem employees did to cause the biocide leak, at least under the Palumbo version, or how they were negligently supervised. And finally, because Mr. Kirchhoff's claims fail, Ms. Kirchhoff's loss of consortium claim necessarily also fails. Multichem requests that the court affirm the summary judgment order. Thank you.
I have several points that I'd like to raise. First, when asked the question about the Roque affidavit by you, Judge Webb, defense counsel conceded. He said it spilled when it was injected into the tank. So defense counsel reads the Roque affidavit in the same manner that I do, that the spill was caused, under the Roque version of events, the spill was caused because the tank was incomplete.
Well,
My second,
Let me follow up then.
okay.
Okay, the statement, quote, "this was human error," close quote. How do we know that that points the finger at Multichem for putting the biocide into an incomplete tank, or to Noble for having given that direction?
Even if we lose on human error, the general statement of how the events occurred, they can't pump biocide into a tank that is incomplete and it spills out and owe no duty, and I think defendants concede that point. But I do want to touch on the omission of the party opponent point, because we know the scope of Multichem's duties on site. It is well known that Noble Energy operates the site. Multichem is just one of several contractors, and their duties on site are specific. All of their duties have to do with chemicals. They provide the guidance, they provide the chemical, they provide the biocide, they provide chemical guidance. Uris testifies to this in his deposition, and we cite it in our opening brief. So we know that everybody on site, their duty from Multichem, their duties all have to do with biocide. And we know at the particular time of the statement at issue, they are being sent to the site to remediate the biocide spill. So when they talk about the biocide spill, they are speaking within the course of their employment. That's my second point. And on the third point, Judge Webb, you did ask, do they need to be experts? And my understanding, if this is an admission of a party opponent, do they need to be experts? For one thing, that wasn't raised, but for another, I really don't think that they do. For admissions of a party opponent, there is no personal knowledge requirement. The Colorado Supreme Court has said as much. And I would ask this court, please do read the Pappas case from the Second Circuit. Please read that case. It's cited in our briefs, and in our opinion, it's on all fours. But given that there's no personal knowledge requirement, I also believe, given the policy concerns for admissions of a party opponent, they don't need to know they don't need to have a factual basis for what they're talking about. We credit these statements because employees are among the best informed about what happens at their place of employment. Furthermore, they're unlikely to make damaging statements unless those statements are true. And all of that is in the Pappas case. And with that, I would ask you to reverse the trial court's determination.
Thank you. We appreciate the arguments of both counsel. The case stands submitted and counsel are excused. We will issue a written opinion in due course. When the tables are cleared, counsel in our third case may set up. I'm going to poll my colleagues and see if we want a short recess.
We're okay.
I'm fine with this.
We will take the third case as soon as counsel are set up. Does counsel have any questions concerning our procedures?
I do not, Judge.
To the extent that there's been a slight turnover in our spectators, again, if you have a cell phone or similar device, please turn it off so the counsel are not interrupted. Otherwise, we're ready for argument in Rahabi versus ICAO.
Afternoon, may it please the court, Mark Elliott, number 18CA0545, on behalf of Mr. Rajabi, who's also present at council table, and my associate Alanit Katzman. As a way of background.
Excuse me, with the bill, okay, the clock's running, fine, thank you.
As a way of background, Mr. Rajabi was injured performing duties as a volunteer firefighter for the city of Arvada. He loves this job. He spends all of his time since his injury, particularly with the development of the CRPS, focusing on trying to return to his position there. Unfortunately, after the injury to his hand, performing those duties, he developed CRPS as a complication. And it's important for the court to understand this condition. It's a debilitating disease. It involves constant burning pain in the involved extremity that often develops and evolves into other parts of the body. It's been dubbed the suicide disease. It's one of the most painful disorders known in medicine. On the McGill University Pain Scale, CRPS ranks 42 out of 50. And just by way of example, untrained childbirth is 40 out of 50. And so that ends at some point with the birth. CRPS is constant and it is chronic. And as has happened in this case, it began in his right upper extremity. It's gone to his left upper extremity, into the bottom of both of his feet. To understand that disease helps to understand the context of why we're here today. And that is to decide the issue of what constitutes a medical benefit under the Workers' Comp Act. A couple things that are important in that regard. First, the statutory language, 842-101. The second thing that's important is the longstanding doctrine of liberal construction of the act itself, which began with the Grand Bargain in 1915, has been affirmed by the Supreme Court 1919 and all the way up until recently in the England case in 2017. The act has to be construed for its beneficent purposes, and the act is interpreted in a way in favor of the rights of injured workers, and compensation benefits, medical benefits are certainly part of that. The other more important thing, I think, finally in that is the Bell 1 case. In 1997, the Court of Appeals decided Bell 1. Bell 1 is a case that decided that child care could be a medical benefit under the act. It reaches that conclusion with facts that are even less compelling than the facts here. The facts here are about housekeeping and yard services that Mr. Rajabi's treating surgeon, Dr. Davis, prescribed to him because of the complications of CRPS. And those services were designed by Dr. Davis, the treating surgeon, to cure and relieve the symptoms that he had, in particular to avoid exacerbation and increase of symptoms. But as important, if not more important, to allow his meaningful participation in the physical therapy that had also been prescribed by Dr. Davis. In that context, those requirements, and in fact, Dr. Davis's opinion in this regard mirrors in lockstep the requirements of the Bell 1 decision in 1997. I think where everybody has gone astray on this case is looking at 18CA, the Sutrek case, and most importantly, the Tarsus case, is there's a focus in those cases on home health care services. There's a focus on whether the individual, as a result of the work injury, needs home health aid. And that home health service could be provided by a medical professional. There's also cases that said it could be a family member. But they're focusing on the fact that the person is, because of the injury, unable to hygiene, unable to toilet themselves, unable to feed themselves. And so focused on that narrow definition of ADLs, those cases look at that issue and say, we're going to look at housekeeping services as an adjunct to that, or as something we add on to that. The person who's performing those services can, at the same time that they're there to help the person get out of bed or help the person go to the bathroom or feed the person, can also do housekeeping chores while they're there. And that's where this whole thing has gone astray. The ALJ in this case focused on that narrow definition of ADLs. All of her factual findings are under that narrow definition. All of Dr. Olson's testimony, which shouldn't have been allowed in the first place for the reasons we discussed later in our brief, all of his testimony was under the wrong standard. It was focused on, does this person need home health care services because they have limited ADLs? And the answer to that question is, that is not the standard. Bell 1 is the standard.
Counsel, I have a question, because in Dr. Olson's report, he references another doctor's report in which Mr. Rajabi had said, Dr. Davis prescribed these home health care services to me to assist in my ADLs. And so then Dr. Olson goes into an analysis of the ADLs and says, you know, he's telling me he doesn't have problems with bathing and dressing and the narrow ADLs that you have described, which really kind of formed the basis for his opinion, and that seems to me is what the ALJ locked onto. And so I'm wondering whether the physical therapy, meaningful physical therapy recommendation in Dr. Davis's letter, was he talking about ADLs? Because it seems like Mr. Rajabi interpreted it that way when he spoke with another doctor. Or is there something else with the physical therapy?
I think you've latched on something correct, and that is there's two different versions of ADLs going on here. ADLs narrowly defined to tie it to the standard in those old cases that talk about it's got to be part of this home health care situation where it's these narrow three, as opposed to ADLs in general. And Mr. Rajabi in the medical records in the case, and there's a site in I think our opening brief that details severe or unable in numerous ADLs that don't directly result in his need for home health care. He doesn't have to have a home health care nurse there to take care of him, but he still has severely restricted, or actually some of his right upper extremity use at the time was unable to do this, that, or the other thing. And those things overlapped with some of the ADLs, were the more narrowly defined one. But again, they missed the point. The fact that he had those ADL limitations were focused on by the judge as it relates to the standard of Tarsus, as opposed to whether or not he needed these things to cure and relieve his symptoms, prevent exacerbation of his symptoms, and to allow him, by not having these setbacks, and when he has setbacks, it's severe, it's debilitating, that when he has those setbacks, then he can't meaningfully participate in the physical therapy.
Mr. Elliott, the panel concluded that it was bound by the credibility findings in it. Why isn't that the case? Yeah.
Well, it's a good question, but it's also infected by the judge using the wrong legal standard. And I think if you look at the conclusions of law in paragraph 10, that's where the judge makes her discussions about credibility determinations. First saying she's questioning Mr. Rajabi for aggressively seeking treatment. Well, first, if you had his condition and you were dealing with the kind of thing he was dealing with, if you weren't aggressively seeking treatment, because the longer you delay treatment, the worse it becomes and the more likely it is to migrate. That's the first thing. The second thing, more importantly, she dismisses Dr. Davis for having like serial prescriptions for and ever changing or clarifying prescriptions that were actually created as a result of the respondent's request for more detail from Dr. Davis about exactly what he wanted in terms of the housekeeping services. But most importantly, the 3 sentences right after she makes those things, she says that she's making those determinations based on the credible testimony from Dr. Olson. The first thing that she relies on is her stated statement that he found that these services were not reasonable, necessary medical expenses. Everyone agrees that that's a misstatement. ICAO agrees it didn't happen. It's not in the record. Secondarily, he then went on to refer to other parts of Dr. Olson's testimony that suffer from the same problem that the ALJ had here, where she was focusing on this narrow definition of ADLs that are focused on the idea, did he prove his entitlement to home health care services and therefore housekeeping services as an adjunct to that? And so because they're infected by the incorrect legal standard, then I don't think you are bound by them in this situation.
Are you asking us for outright reversal or for remand with direction as to what you argue and we, I suppose, could accept is the proper legal standard?
Well, yeah, initially, I think we're asking for outright reversal based on the record as it exists right now, and that's twofold. First, if you look at Dr. Olson's testimony under the correct legal standard, he provides a number of factors not focused on that limited definition of ADL that would mandate the award of benefits in this case. If you take the further step and question, as we have, not the judge's, it's not a discovery sanction issue, it's the judge's admission of Dr. Olson's report in this context. With those things removed from this case, this record demands an award of benefits under the Bell 1 standard, because these facts meet the Bell 1 standard plus. If child care constitutes a medical benefit under Bell 1, these meet the the same standards under Bell 1 plus more. And I'm going to reserve my last 3 minutes.
May it please the court, David Bennett, bar number 46444, appearing on behalf of Arvada Fire Protection District. I think what's key here is to give some perspective on the work comp appellate process. The statute or the act allows for kind of a narrow review, and what's key there is that there's substantial evidence supporting that decision that the ALJ makes. Here, the ALJ made credibility findings And the panel below at ICAO said that they were not able to reverse those credibility findings based on the record below. What I would also like to say is that the burden is on the claimant to show entitlement to benefits under 841-301 and also under Faulkner v. ICAO 12P.3, 844, Penn site 846. And because of that burden, those credibility findings are very important because those credibility findings go to both claimant's testimony, the medical records that the ALJ considered that were submitted at the hearing, as well as the medical records dealing with what Dr. Davis was prescribing as treatment for claimant or as things that he needed assistance with outside of his home in, as far as yard work. So with that context, both that there's limited review on appeal and that it was claimant's burden below to prove entitlement to benefits, I, in reading the ALJ's order, would frankly argue that she did apply the correct legal standard here. In the court file, page 298 is where she begins talking about the Bologna standard, paragraph 8, and then into paragraph 9. She quotes at length from that standard, and frankly, she goes into more of an analysis than what I would say we typically see from ALJs. She accurately summarizes that governing law, and she articulates this standard. And this court has repeatedly found where there is citation to the law and that the ALJ simply concludes that they, and I would say that this is actually the first sentence of paragraph 10. Here the judge concludes that claimant's request for in-home services and yard service is not reasonable, necessary to cure and relieve the claimant of the effects of the April 23, 2017 injury, nor is it incidental to obtaining medical treatment. And under both, the kind of the case that sets it out, magnetic engineering versus ICAO 5P.3D 385, which is cited in the briefs, and also Loughborough, announced by the Supreme Court in 2011, citation 321 P.3D 548, and it's a little long opinion, so the Penn site is 553. Basically, work comp, the ALJ is not held to a crystalline standard in expressing findings of fact or conclusions of law. And if their order simply reflects that the ALJ concluded that these services were not incidental, that's not a basis for a review that she was a little, wibbly-wobbly with her language. Additionally, I would say that there's substantial evidence in that the ALJ, as I said earlier on the credibility determinations, first determined that claimant was aggressively acquiring work comp benefits. And if you read through the opinion, she cites several different instances where she believes that that is taking place. First, that he declined certain treatment and immediately kind of diverted to assisting with housework and yard work. That's on page 295 in the court file, and that would be paragraph, excuse me for a moment, paragraph 7. Then there is a lengthy discussion about claimant directing Dr. Vanderhorst who to refer him to for a second opinion. And for context, often that doesn't happen in work comp because we have a specific provision that limits directing care both for the employer and both for the claimant. So, typically you might have an argument about that that's not a proper referral. Then there's a 45-minute conversation with Dr. Davis at night and goes into detail there. It appears that that's somewhat of the basis of the decisions that happen here. She specifically cites to that in the record. And then she talks about when respondents actually did provide some home assistance, that it was refused because it was unsatisfactory. And that is on page 296 in the court file. So based on all of that evidence, she did not find claimant to be credible. And then she also found Dr. Davis not to be credible because his prescription began to vary. She also points to a couple different places on where she believes that these interactions between claimant and Dr. Davis may have had some impact on that variation in the prescription. And so based on those determinations, as well as her review of the medical records, she simply finds that claimant did not meet his burden of proof.
Let me ask you, counsel, because I'm trying to probe the scope of what you're asking us today. Are you asking us to hold that as a matter of law that household chores and yard work are not medical treatment as used in the statute?
No, and so I think that it's important to look at Ballone and the procedural history on Ballone. So in Ballone, the ALJ actually did find that the services that were prescribed were medical services that were reasonable and necessary to cure and relieve the claimant. That was reversed by ICAP on a legal basis. Right. And then that was reversed by the Court of Appeals, basically saying, no, that's a factual determination that the ALJ needs to make. Here, our procedural posture is that the ALJ determined that they weren't reasonable and necessary. The ALJs have that large discretion to make those kinds of factual determinations. That's part of the reason why we have this narrow scope on appeal. And so I think that's the protection. We're simply asking for you to keep the standard as a factual determination for the ALJ and not make it a matter of law.
Okay, thank you.
And then,
So just
yes.
to echo, so your position is that in some cases, assistance with ADLs might meet the reasonable necessary test, but it just didn't here as found as a matter of fact by the ALJ?
Yes, that is our position. And then, as far as the substantial evidence argument having to do with the evidentiary issues, I would argue that the substantial evidence is what I've just reviewed, having to do with her credibility determinations on the claimant, as well as Dr. Davis and the medical records. There may be issues with Dr. Olson's testimony, and there is certainly an issue with her conclusion on what she misstates that he actually testified to. But I think over the broad scope of the record and her actual conclusions on why she was denying this, having to do with the credibility determinations, that is harmless error on her part. And then to the last argument having to do with the medical treatment being incidental, I don't read this as a math problem. I simply read it as she concludes that incidental is not accompanying a medical treatment program. It could be both that it's a minor cost, but it could also be that it simply isn't part of the medical treatment program that the doctors were prescribing or recommending, or that he failed to prove that it should be incidental to that. And I have nothing more, Your Honors, unless you have more questions for me. Thank you very much.
So this is not a substantial evidence case, and here's why. First, you can't have a substantial evidence case when you apply the wrong legal standard to make your findings of fact. You applied the wrong legal standard. You focused on this narrow definition of ADLs, focused on the Tarsus case, not on the Bell 1 standard. Even though she cited the Bell 1, her focus in the findings of fact were on Dr. Olson's testimony that either she mischaracterized in one instance that everyone agrees on, that the ALJ was under the impression that Dr. Olson testified that the household services and yard services was not a reasonable and necessary medical benefit based on Dr. Olson's opinion. That's got to infect the ALJ's entire view of this issue. So it's not a substantial evidence case when you apply the wrong legal standard and you're under the misimpression that a doctor has testified to something that he didn't. Then you take it a step further, and she relies on Dr. Olson's testimony to make all of her determinations in this regard, and those Dr. Olson never says, and there is no evidence in the record that this prescription for household services and/or for yard services was not part of his medical treatment regimen. Dr. Olson acknowledged that it was prescribed by his doctors because of his CRPS. Dr. Olson acknowledged that the kinds of things he was being asked to do could flare his CRPS. This is a serious medical condition. And so for those reasons, this is not a case that we're just talking about substantial evidence. We're talking about the wrong legal standard being applied. And at a minimum, Judge Webb, that requires to go back to the judge and have the factual findings made under the correct standard if there's a remand. The next thing is on this incidental question, it's done without any analysis of the facts of the case. Okay, so there's no analysis of what it means to be incidental. And the expenses since this time have gone up dramatically from where we were at the time, but the comparison of cost is exactly what Judge Hume talked about in his special concurrence in Tarsus. He said, you have to put on some evidence about that. We did here, and if you compare them, it is incidental, number one. Number two, counsel said that there was evidence in the record that the judge could rely on to find that that was not part of the treatment plan. Well, there's no evidence to support that idea. There was only evidence that this was specifically part of his treatment plan, and it was specifically designed to cure and relieve the effects of his work-related injury, which is where we go back to the statute. That's exactly what the statute says. Thank you.
We appreciate the arguments of both counsel. This case stands submitted. We will issue a written opinion in due course. On that basis, counsel in this case are excused, and since we have nothing else on our afternoon docket, the bailiff may announce a recess.
All rise. The court will be in recess, subject to call.